Welcome back to the Deep Dive. We're here to get you up to speed on complex topics fast. Today, we're continuing our journey through the MPE, the Manual of Patent Examining Procedure. Think of it as the rulebook for getting a U.S. patent. We're diving into Chapter 700, Examination of Applications, and zooming in on one particular section, MPP Section 715. That's the one titled Swearing Behind a Reference Affidavit or Declaration under 37 CFR 1.131A. Bit of a mouthful. Our goal for you listening in is to really unpack what this swearing behind thing is all about. We're using excerpts right from the MPP, so you get the real deal on when this comes up and why it matters. And before we jump in, a big thank you to Mike Shepard, the creative director behind this whole audio series. He made this possible.
Absolutely. And Section 715, it deals with a pretty specific tactic in patent prosecution. It's about how you can sometimes overcome a piece of prior art, something the examiner says came before your invention, but it involves specific rules, specific legal sections like 37 CFR 1.131A, and crucially, specific kinds of proof.
Okay, let's get into it. Swearing behind a reference. It sounds intense. What's actually happened?
Yeah, it does sound dramatic, but really it means you're filing a formal statement, like an affidavit or a declaration. It's done under a specific rule, 37 CFR 1.131A. And the whole point is to show the Patent Office, the USPTO, that you actually invented your thing before the date of whatever prior art the examiner is pointing to.
Ah, okay, so you're proving your date was earlier.
Exactly. And if you can convince them, if you successfully prove that earlier date, then that piece of prior art might get knocked out. It can't be used to reject your patent claims anymore.
Now, here's something I found really interesting. Who can even do this? Is this a standard tool for anyone filing a patent now?
That's a really key point, and the source material is clear on this. This whole procedure in Section 715, using that 1.131A affidavit, it's mainly for patent applications that fall under the old rules. We call it pre-AIA law.
Pre-AIA, meaning before the American Invents Act.
Right. Before March 16th, 2013, that's when the U.S. switched from a first-to-invent system to basically a first-inventor-to-file system. So if your application was filed after that date, under the current AIA rules, this specific swearing behind method generally not an option for you.
Okay, so it's kind of a legacy thing, mostly.
Yeah.
Relevant for older applications still winding their way through the system.
Mostly, yes. It's definitely a tool from that first-to-invent world.
Yeah.
But there's a little wrinkle. The MPP does mention one situation where it can still pop up, even for newer applications. If you get a rejection based specifically on pre-AIA 35 U.S.C. 102G, that's prior art, based on someone else inventing it first here in the U.S., then you might still be able to use a 1.131A affidavit.
Huh. Why is that?
Well, the source mentions that this type of prior art, 102G, can sometimes still apply to AIA applications if they claim priority back to an earlier application filed before March 16th, 2013. So it's complex, but yeah, it's not completely gone. Its main home is definitely pre-AIA cases, though.
Got it. So let's say you're in one of those situations, maybe an older case, or it's like a 102G thing. What do you actually have to show in this affidavit to prove you were first?
The MPP lays out two main paths, essentially. You have to provide convincing evidence that before the effective date of that prior art reference, you either 1. Achieved actual reduction to practice of your invention. Basically, you built it or ran the process and proved it worked.
Okay, so you made it work.
Right. Or path number 2, you had prior conception. That's the moment you had the complete idea figured out in your head, and you followed that up with continuous diligence.
Diligence, like working hard on it.
Exactly. Consistent, reasonable effort without big, unexplained gaps, starting from just before the reference date all the way until you either got it working later, reduction to practice, or you filed your patent application.
That makes sense. So it's not just I thought of it first. You either have to show you finished it first or you thought of it first and kept plugging away at it until you finished or filed.
Precisely. It's about proving that timeline of invention. And the MPP is also very specific about when you can use this 1.131A affidavit. And just as importantly, when you can't.
Okay, let's break that down. When is it appropriate? When is this affidavit your potential friend?
So, according to the source, you can use it to get around prior art references that fall under certain pre-AIA sections. Pre-AIA 102A, 102E, or that 102G we just talked about. But there are conditions. Big ones. First, the reference can't be too old. Its effective date has to be less than 1 year before your effective filing date.
Like a year, okay.
And second, really critical, the reference cannot involve interfering subject matter. We can circle back to what that means exactly.
Right, and when is it definitely a non-starter?
Yeah.
When will this affidavit just not work?
Well, the source lists a few key situations. You cannot use it if the reference falls under pre-AIA 35 U.S.C. 102b. Those are the statutory bars.
Statutory bars,
Yeah.
like being too late to file.
Exactly. Things like if the invention was already patented, described in a publication, in public use, or on sale more than 1 year before you filed. If that's the case, under the old rules, you're just marred. Doesn't matter when you invented.
Makes sense. What else?
Also, like we just mentioned, it doesn't work if the reference involves interfering subject matter. Basically, if the reference you're trying to swear behind actually claims the very same invention you're trying to patent.
Ah, so if you're both claiming the exact same thing.
Right. That situation, under the old rules, would typically lead to something called an interference proceeding to figure out who the first inventor truly was. The 1.131A affidavit isn't the tool for that direct fight. And finally, you can't use it if you've kind of shot yourself in the foot by already admitting somewhere in your application that the thing you're trying to swear behind is prior art.
Okay, let's make this really concrete with that example from the source. Can you walk us through that?
Sure. So imagine you filed your patent application. The examiner rejects your claims based on a U.S. patent someone else got. Let's say that other patent was filed 6 months before you filed your application.
Okay, 6 months earlier.
Right. Scenario 1. If this is a pre-AIA case, and that patent doesn't claim the exact same invention, and it's only 6 months older, less than a year, then you might be able to use a 1.131A affidavit. You'd need to provide evidence showing you either, got your invention working before their filing date, or you conceived it before their filing date and were diligent right up to your filing. If your evidence is good, you swear behind it, and the rejection based on that patent goes away.
Okay, that's when it works. What about when it doesn't?
Scenario 2. Let's take that same patent reference. But now imagine its filing date was actually, say, 15 months before yours. More than a year.
Ah, the statutory bar timing.
Exactly. Or imagine that patent claims the very same invention you're trying to claim interfering subject matter. In either of those cases, trying to file a 1.131A affidavit, it's just ineffective. The rules block it. You can't swear behind it then.
That example really helps clarify the boundaries. Now, you keep mentioning evidence and proof. What kind of stuff are we talking about? You can't just sign a piece of paper saying, I invented it first, right?
Oh, definitely not. This is where the old first-to-invent system demanded really good record keeping. The source mentions you need solid, objective proof. Things like original exhibits, maybe drawings or prototypes, detailed laboratory notebooks showing dates, experiments, results, or statements from witnesses who saw your work and can back up your timeline, people who aren't co-inventors, ideally.
So real documentation.
Yes, documentation that convincingly shows your development timeline. It needs to clearly prove either that actual reduction to practice or that conception followed by continuous diligence happened before the date of that prior art reference. It really highlights how important keeping detailed, dated records was under that system.
And the source mentioned examiners use specific form paragraphs for this. That sounds very procedural.
It is. It signals that examiners have a structured way to evaluate these affidavits. They're looking to see if the evidence presented legally meets the requirements for establishing conception or diligence or reduction to practice. It's not just a judgment call, it's applying specific legal standards to the evidence. And, it's worth just briefly contrasting this with how things often work now under the AIA. Other parts of the MPP talk about a different rule, 37 CFR 1.130.
1.130. How's it different?
Well, 1.130 declarations are used under the current AIA system. They're mainly for overcoming prior art that came from your own public disclosure, or maybe from a coworker at the same company, if that disclosure happened within the 1-year grace period before you filed. So 1.130 is tied to the first inventor to file exceptions dealing with your own prior disclosures. Sections 715 and 1.131A. That's the old first to invent tool for proving you invented before someone else's prior art. Different systems, different tools.
Okay, that's a helpful distinction. So let's try to wrap this up. We've dug deep into MPP Section 715. What's the main takeaway?
The core function of MTP Section 715 and the 1.131A affidavit it describes is really providing a pathway for patent applicants, primarily under the older pre-AIA rules, to prove they invented something before certain types of prior art references. It's a mechanism to overcome rejections by establishing an earlier invention date, but, and this is key, it comes with very strict requirements about timing, the type of prior art, and the need for strong, verifiable evidence of your inventive timeline, either getting it working first or thinking of it first and being diligent.
It really is fascinating how these layers of patent law work and how the effective date of your application can totally change the rules you're playing by. Remnants of the old system still clearly matter in some cases.
Absolutely. And thinking about the level of detail required those lab notebooks, the witness statements, proving diligence over time, it raises a question for you, the listener. What does this intense focus on proving a historical timeline of invention, which was central to the old first to invent system described in 715, tell you about what it means to establish invention rights, especially when you compare it to the arguably simpler first inventor to file approach we have now? What stands out to you as the most interesting or maybe the most challenging part of this whole swearing behind process? Something to think about.
Definitely something to chew on.
Yeah.
Thank you for joining us for this deep dive into MPP Section 715.
And let's just repeat the disclaimer. This summary of the MPET was generated using AI tools, including ChatGPT and Notebook LM, and may contain errors or omissions. It's for general educational and informational purposes only. It isn't legal advice or a substitute for formal instruction. For authoritative guidance, please consult the official MPEP, a qualified instructor, or a registered patent practitioner.
That concludes this deep dive.